This is Marty Chizik with Charism Home Care and Eldercare Services. We're at our offices here in Downers Grove, and I have a guest with me today. Michael Stewart is a CPA and attorney who does estate planning. And Michael and I want to talk a little bit. We sometimes forget that there are all three of those sort of legs on the wheel. There's the legal and the financial and the medical. So Michael kind of has that expertise of the legal and medical, but we're going to talk more about the legal, I think, today. So, Michael, why would one of the people that work with us come see you? I mean, what kinds of things do you see that we need our audience to understand better?
Well, I think a lot of people don't understand what authority people have to act on your behalf. If you have issues, if you have desires that you want to have promulgated, that won't happen unless somebody has the authority to act. So it usually takes some kind of power of attorney or a healthcare power or something like that to get them to be acting on your behalf, and that's what gets the process started.
Right, and so what we see, at least on the healthcare side, is, well, Mom told me when I was 10 years old that she wanted A, B, and C done,
Yeah.
right?
Yeah.
Well, now what do we do? Because you're one sib and I'm the other, and we heard totally different things.
Yeah, and it's much more difficult, I think, as the parents get older. Number one, they may not want to talk to the kids. They're afraid to talk and afraid to convey something, or they may consider that they're going to create a problem or an issue between the kids. But I think communication is the key. The sooner that the parents talk about the issues, because their kids are going to wind up making those decisions, and the sooner they convey those issues to the kids in a broad setting, both of them there. But also, I would suggest writing it down so there's no confusion
Absolutely.
later on.
Absolutely. And what might we write down? I mean, you have a power of attorney for property, so what's the problem?
Well, first of all, most of the properties of attorney, the powers of attorney for property that they have are very general. So there's no definition of what happens. So for example, you have a power of attorney to deal with the real estate or the checking accounts and things like that. Do you have the authority to take someone and say, listen, you have to go to a nursing home, I have to admit you because you're not competent to do that? That takes a power of attorney that specifically authorizes that. Most of the powers of attorney that are drafted are very statutory and very broad, and they don't really define what it is you want. So you want to be much more concentrated on what exactly you want in those powers of attorney, and have the ability to talk to your family about those exact things that you want, or the particular facilities you want to go to, or you particularly want to avoid if you had to go there.
Right, and so what ends up happening in the world that I'm in is that maybe we didn't know Mom and Dad's assets even. We didn't even know how much money they had.
Yeah.
And so we're, looking at a Chevy Vega for a facility, and we find out that, maybe Mom and Dad could live in their own home with live-in care.
Yeah.
And if we don't share, I don't do very well with people I work with trading brainwaves.
Hasn't worked in a long time.
Yeah, and then we look at people that maybe have some confusion. And so what do you do?
Well, if there's confusion, then you're probably looking at a guardianship, because if Mom or Dad hasn't given the authority to someone beforehand and they own the assets, the only one that can transfer that ownership or the authority is them. If they're confused or they're deemed to be incompetent, or a doctor says they shouldn't deal with their financial affairs, then a lawyer like me gets involved to appoint someone the guardian, which means the judge essentially takes control to take care of the person who's the guardian for. And they also have to appoint a guardian ad litem, which is another lawyer, that will be the representative for the court of the person who's the ward of the estate. So it's a very cumbersome process. It's expensive. It takes a long time, and anything you do on behalf of that person goes before the judge, who's not somebody the family knows, doesn't know what the family situation is. So oftentimes they're not as compatible with the issues that you had.
And now the judge, so the GAL, or the guardian ad litem, would have to bring my needs, if I'm the senior, and their guardian for me would have to bring my needs in front of the court, in front of the judge, and then the judge makes makes the final determination.
They do, but they often don't know, because the guardian ad litem gets appointed after the person is on the road to being sick. They may be confused as to what they want. They may not have really articulated it well. So it's better if you have that discussion with someone beforehand, and again, have it in writing, so that the GAL knows that there's some history behind this particular thing. And that way the family's better off protected, but the ward of the state, the person who's getting the guardianship, they're going to be better protected by having that done.
So what we have learned today, talking to Michael, is procrastination has a heavy toll.
It does.
And a heavy cost.
It does.
It's not easy to have these discussions,
No.
but they are absolutely essential.
Yeah, I think as long as the family talks about it and they talk about real issues, they're much better off.
Great. Well, thanks for stopping by. This is Marty Chizek and Michael Stewart, and we just talked today about guardianships and legal issues that seniors and their families have to work with. Thanks for stopping by, and we'll see you again soon.